For 248 years, the United States existed under a polite fiction. We assumed, perhaps naively, that the person sitting behind the resolute desk was a citizen first and a leader second. We assumed that if a president committed a crime, a real gritty, street-level crime, the system would handle it. We never needed a rule book for this because we never had a president who tested the absolute boundaries of the law like a crash test dummy. Until now. The Supreme Court has finally spoken, and if you're just reading the headlines, you might think, Donald Trump popped a bottle of champagne. Absolute immunity, they said. Official acts are protected, they wrote. It sounds like a victory lap. It sounds like the Teflon Don has done it again, slipping through the fingers of justice like he's greased with legislative loopholes. But look closer. Read the fine print written in the invisible ink of Chief Justice Roberts' opinion. This wasn't a coronation. It was a cage match. Yes, the court gave the executive branch a shield. They ruled that for core constitutional duties, the president is untouchable. You can't prosecute a president for commanding the military or vetoing a bill. That makes sense. We don't want presidents looking over their shoulders every time they make a tough call. But here is the sting in the tail, the part that should have Team Trump sweating through their suits at Mar-a-Lago. Unofficial acts have zero protection. Zero. None. Nada. The court has drawn a line in the sand that never existed before. They have bifurcated the man from the office. There is President Trump, the head of state, and then there is candidate Trump, the guy desperate to stay in power. The former is protected. The latter is just a private citizen on a rampage. And that private citizen is now standing naked before the law. Think about the implications. The strategy for the Trump defense team has always been simple. Delay, deny, and deflect. They wanted to run out the clock. They wanted to claim that the very essence of the presidency acts as a magical force field against all accountability. That argument is dead. It didn't just die. The Supreme Court drove a stake through its heart. By defining what is protected, they implicitly highlighted everything that isn't. The illusion of invincibility is shattered. For years, the narrative has been that a former president is a species apart, a sort of American royalty that we are too polite to drag into a criminal court. That era ended this week. The justices, even the conservative ones, appointed by Trump himself, admitted that the king is subject to the law the moment he steps off the throne and starts acting for his own personal gain. This ruling doesn't end the war, it changes the battlefield. We are moving from a philosophical debate, can you charge a president, to a gritty, factual street fight. Was this specific phone call a crime? And that brings us to the most dangerous territory for Donald Trump. Because when you strip away the official act defense from a man whose entire political brand is built on blurring the lines between the national interest and his personal ego, you are left with a very long list of actions that look suspiciously like common felonies. The shield is up, yes, but it's smaller than he hoped, and he's holding it over the wrong parts of his body. The question now isn't about the majesty of the office. It's about the messy, here lies the trapdoor. If you listen to the pundits on cable news immediately after the ruling, you heard a lot of wailing about how the Supreme Court just crowned a king. But slow down. Read the ruling again. The court didn't just hand Trump a shield. They handed the prosecution a scalpel. The distinction between an official act and an unofficial act sounds academic, but in practice, it's going to be brutal. The Supreme Court remanded the case back to the lower court, specifically to Judge Chutkan, to sift through the indictment line by line. They have to decide, was this tweet official? Was that meeting with state legislators part of the presidency, or was it the desperate scrambling of a losing candidate? Trump's team loves to muddy the waters, but this process forces the water to be crystal clear. And here is the irony. To prove he is immune, Trump's lawyers will have to drag every dirty detail into open court before a trial even begins. We are looking at extensive fact-finding hearings. This is essentially a mini trial without a jury. Let's look at the fake electors scheme. Trump argues he was protecting the integrity of the election, a core presidential duty. But special counsel Jack Smith is going to argue that organizing slates of fake electors in states you lost isn't protecting the Constitution, it's campaign fraud. It's a private act for private gain. The Supreme Court explicitly said that the president has no immunity for unofficial acts. And guess what? Campaigning is, by definition, unofficial. You don't campaign for yourself as the commander-in-chief. You campaign as a politician. When Trump allegedly pressured Georgia officials to find 11,780 votes, was he executing the laws of the United States, or was he trying to save his own skin? The answer seems obvious to anyone with common sense, but now a judge has to write it down in a legal order. This destroys the delay strategy in a way Trump might not have anticipated. Yes, the actual trial might be pushed back, maybe even past the election, but the evidence, the testimony, that's going to come out in these hearings. The public is going to hear the receipts. We are going to see the difference between the office and the man laid bare. Furthermore, the D.C. Circuit Court, which this case bounces back to, has already signaled they aren't playing games. They've established that immunity is narrow. They know that if they broaden the definition of official acts too much, they essentially legalize tyranny. So they are going to be surgical. So while Trump celebrates the headline, the text of the ruling creates a minefield. He has to walk through it step by step, explaining why every chaotic, self-serving action he took on January 6th was actually a duty of his office. Good luck with that. You can't claim you were putting out a fire when everyone saw you holding the gasoline can. The official act defense is a double-edged sword. It protects the presidency, sure, but it leaves the candidate completely exposed. And make no mistake, it was candidate Trump who was calling the shots in those final frantic days. Now, let's talk about the ultimate escape hatch. The nuclear option. For years, legal scholars and barstool pundits have debated a question that sounds like a Zen koan for criminals. Can a president pardon himself? In Trump's orbit, this is treated as a given. The logic goes, if I win in November, I'll just sign a piece of paper on day one and all these federal cases disappear like magic. It's the ultimate power move. It's also, according to the courts and basic common sense, a complete legal fantasy. The D.C. Circuit Court dropped a hammer on this idea, and the Supreme Court didn't rush to pick it up. The reasoning is devastatingly simple. The pardon power, historically and constitutionally, is an act of mercy. Mercy is inherently a transaction between two people. One person grants it, another receives it. You cannot grant mercy to yourself. That's not mercy, that's impunity. That's just declaring yourself above the law. If a president could pardon himself, the Constitution would be a suicide pact. A president could theoretically murder a political rival in the Oval Office, sign a pardon with the murder weapon still in his hand, and walk away. The Founding Fathers were revolutionaries, not idiots. They didn't overthrow a king just to create a system where a president could govern like a mob boss with a laminated get-out-of-jail-free card. Look at history. When Richard Nixon was facing the abyss during Watergate, he didn't pardon himself. He resigned. Why? Because even Nixon, a man not known for his ethical restraint, knew that a self-pardon wouldn't hold up. He needed Gerald Ford to do it for him. Ford's pardon was controversial. It likely cost him the 1,976 election, but it was legal because it came from someone else. Trump doesn't have a Gerald Ford. He only has himself. And here's the other problem with the self-pardon fantasy. It only applies to federal crimes. The President of the United States has absolutely no power over state courts. The convictions in New York, the RICO case in Georgia, a presidential pardon is worthless there. It's like trying to use a Starbucks gift card at a gas station. It has no currency, so the walls are closing in from two sides. On the federal side, the self-pardon is a legally untested theory that is likely to be struck down the moment he tries to use it. On the state side, he's already exposed. This brings us to a terrifying realization for the former president. The legal system isn't a maze anymore. It's a conveyor belt. The exit doors, immunity, self-pardons, delays are being locked one by one. The strategy of simply winning the election to stay out of jail is based on a misunderstanding of how the pardon power actually works. He is betting his life on a legal theory that most constitutional scholars treat as a bad joke. The illusion of the self-pardon has kept his morale up. It's kept his donors writing checks. But when you strip that away, you are left with a 78-year-old man facing the very real possibility of dying in a concrete room, regardless of whether he wins the election or not. Politics is a game of opinions, but the law is a game of statutes. And underneath all of that, there is a force that no Supreme Court ruling can overrule: biology. Let's strip away the MAGA hats and the resistance banners and look at the cold, hard calculus of this situation. Donald Trump is 78 years old. In the eyes of the actuarial tables used by life insurance companies, he is already in the red zone. Now, look at the statutes he is charged with violating. We aren't talking about unpaid parking tickets here. The charges regarding the mishandling of classified documents, specifically under the Espionage Act, carry maximum sentences of 10 to 20 years per count. Obstruction of justice? That's another 20 years. Conspiracy to defraud the United States? 5 years. Now, any criminal defense attorney will tell you that nobody gets the maximum sentences, usually run concurrently, meaning you serve them at the same time, not back to back. So the media headlines screaming about 700 years in prison are sensationalist nonsense. But here is the terrifying reality for Donald Trump. He doesn't need a 700-year sentence. He doesn't even need a 50-year sentence. If Donald Trump is convicted and sentenced to just 5 to 10 years in federal prison, that is, statistically speaking, a life sentence. Think about the math. If a trial concludes in 2025 or 2026, and he receives a standard sentence for these types of crimes, he would be entering the federal penitentiary system as an octogenarian. He would be an 80-year-old man stripped of his Secret Service luxuries, or having them heavily modified, stripped of his private jets, and placed in a controlled environment. Father Time remains the one prosecutor who has never lost a case. And this isn't a country club prison scenario like people imagine from the movies. Federal prison camps are minimum security, yes, but they are still prisons. The medical care is basic. The stress is immense. For a man who has lived his entire life in gold-plated penthouses, the physical and psychological shock of incarceration at that age is incalculable. This reality explains the desperation we see. It explains the scorched earth legal tactics. Trump isn't just fighting for his political legacy or his reputation. He is fighting for his literal life. He knows that if the gavel drops and the sentence is read, he will likely never breathe free air again. He will die in custody. The Supreme Court's ruling on immunity didn't change these numbers. It just narrowed the path to get there. By stripping away immunity for unofficial acts, the court ensured that if the prosecutors can prove the candidate Trump theory, the sentencing guidelines remain in full effect. There is no senior citizen discount in the federal sentencing manual for espionage or obstruction. We also have to consider the impeachable offenses ruling. The court clarified that if a crime is serious enough to be impeachable, it can still be prosecuted in regular court. Attempting to overturn an election is the definition of a serious crime. The judges are signaling that high office doesn't grant you a high ground when it comes to the consequences. So when you see Trump on the campaign trail screaming about a witch hunt, understand the subtext. He's not running for president just to make America great again. He is running to stay out of a 6x8 cell. The White House is now the only retirement home he can afford. The alternative is a grim, bureaucratic end in a federal medical facility. The stakes have transcended politics. They are now purely existential. So, where does this leave us? Where does it leave the country? We have arrived at a singularity in American history. For the first time ever, a major political party's nominee is running a campaign that doubles as a legal defense fund. The Supreme Court's ruling has clarified the rules of engagement, but it hasn't stopped the war. In fact, it has raised the stakes to a level that is almost impossible to comprehend. The election on November 5th is no longer just a choice between two ideologies, two platforms, or two visions for the economy. It is a referendum on Donald Trump's freedom. It is a zero-sum game with the highest possible wager. If Donald Trump loses the election, the protective bubble bursts instantly. He becomes irrevocably a private citizen. The Department of Justice will no longer be restrained by the 60-day rule or the delicacies of investigating a sitting president or a candidate. The official acts hearings will proceed. The trials will be scheduled. The conveyor belt we talked about earlier will speed up. Without the power of the presidency to shield him, the sheer weight of the evidence and the actuarial math will likely crush him. He will spend his twilight years fighting a losing battle against the United States government. But if he wins, we enter a constitutional crisis that makes Watergate look like a parking dispute. We will have a president-elect who may be a convicted felon in state courts, trying to dismantle the federal prosecutions against himself. He will test the boundaries of the executive branch like never before. He will try to fire the special counsel. He will try to issue that self-pardon we discussed. He will try to use the Department of Justice as his personal law firm. And the Supreme Court, having just ruled that official acts are immune, will have to decide if dismantling your own prosecution counts as an official act of the presidency. This ruling has stripped away the ambiguity. It has told us that the system can hold a president accountable, but only if the facts are clear and the will is there. It has also told us that the ultimate jury isn't just the 12 people sitting in a DC courtroom, it's the millions of people going to the ballot box. Donald Trump knows this. That is why he is cornered, and a cornered animal is the most dangerous kind. He isn't fighting for a policy. He isn't fighting for a tax cut. He is fighting to avoid the cage. The slogan, "Make America Great Again," has silently been replaced by a more urgent personal mission, "Keep me free." The judge has stripped his final legal shield. The official act defense is a leaky boat. The self-pardon is a myth. The clock is ticking. The only shield left is the one he has to win from the voters. It is strictly binary now. There is no middle ground. There is no plea deal on the horizon. For Donald Trump, the road ahead leads to only one of two places: 1600 Pennsylvania Avenue, or a federal penitentiary. The king is naked, the trap is set, the math is brutal. And the whole world is watching to see if he can pull off the greatest escape act in history, or if the law finally catches up to the man who thought he could outrun it forever.